We have with us today Dr. Gopinath Shenoy, a practicing advocate and renowned medico-legal expert. He has also been a judge of the Mumbai Consumer Court. Thank you so much for joining us, Dr. Shenoy. My first question to you is, what are the different kinds of avenues available to a consumer in India in case they are dissatisfied with the services provided by a doctor?
According to me, there are 4 avenues today open to a disgruntled patient. The first one is going to be the criminal machinery. He can activate the criminal machinery, and whenever the criminal machinery is activated, the starting point is invariably a police complaint. You go to the police station, lodge a complaint, the criminal machinery gets activated. That is the first avenue. The second avenue, which is more commonly utilized or used by the patients or their relatives, is the consumer courts. They can definitely go to the consumer forum, or they can go to the consumer commission and put a complaint against the doctor, and the civil machinery automatically gets activated. The third place where a disgruntled patient can go or can take the doctor is the medical councils. Every state has a medical council. The patients can file a complaint against the doctors in the medical council, and then the medical council will take up the issue and will do whatever is required. And the last avenue, according to me, which is very important, which is of late coming up, is the Human Rights Commission. You know, a patient can also file a complaint against the institution and the doctor with the Human Rights Commission, and the Human Rights Commission can also examine the issues. But the only point here in Human Rights Commission is, Human Rights Commission has no jurisdiction to act against a private medical practitioner or a private hospital. But whenever it's a state-run hospital, a government hospital, a municipal hospital, the Human Rights Commission definitely can come to the rescue of the patients.
So what are the key tests and standards that courts in India have been applying for cases of medical negligence?
In India, the courts basically adopt the pattern that is followed by the UK courts, and the common standard that the courts go by is the Bolam's doctrine. What does the Bolam's doctrine say? Bolam's doctrine says that the standard of care that is expected from a doctor is not the best of the standards available, or it need not be the worst of the standards available. If at all this standard is somewhere in between, that is known as a reasonable standard, the doctor is supposed to have done his job. So what the law expects today is that the doctor need not be the best doctor, the doctor need not be the worst doctor, but if at all he is somewhere in between and he renders services as is expected to be reasonable, I think he has done his job. This is the most important fundamental on which most of the judgments of the Supreme Courts are given today. This particular Bolam's doctrine is purely imported from the UK courts.
In case of doctors who are affiliated with hospitals, to what extent would the hospital be liable for the negligent acts of that doctor?
I think this question deals with something known as vicarious liability. And now normally what happens is, suppose A messes up, A is the one who has to pay compensation. That is what the general belief is, and that's a correct belief. But in certain situations, when A creates a problem, A does not pay compensation, but it is going to be B who pays compensation. Now who is this B? This B invariably is the institution. So the law says, whenever there is a relationship between two people, which is that of a master and a servant, or an employer and an employee, or a principal and an agent, then for the acts of the employee or the acts of the agent, it is going to be the employer or the principal who is liable to pay compensation. This in the law of torts, this is there in the law of torts, and is known as vicarious liability. It is also known as respondent superior. That means a person who is economically superior, let that person pay compensation. That is what is the belief. Now the Indian courts have also endorsed this, and the Supreme Court has come out with a very beautiful judgment, which we commonly call as the Savita Garg judgment, wherein this particular fact has been elaborated. The Supreme Court has gone to the extent of saying, if the doctor is not made a party, it doesn't matter, but the hospital must be made a party, because normally the patients come to a place looking at the name of the institution and not looking at the name of the doctor. So institution is always held accountable. That does not mean that the institution will keep on paying compensation with respect to their employees. The law of torts is very clear. The law of torts says that the institution can recover this amount from the erring employee, but the only thing is that the recovery has got to be done in installments.
One of the avenues that you mentioned was about approaching the Medical Council of India. Could you tell us about the effectiveness with which the MCI and state medical councils are taking up disciplinary action against doctors?
First and foremost, I would make one suggestion over here, and that suggestion that I'm going to make is that what really needs to be changed today is the code of medical ethics. The code of medical ethics that is in force today is a code that was enacted in the year 2002. You know, like the IT industry, the medical industry is also really moving very fast, and lot of changes have now come in. What was ethical in the year 2002 need not be ethical today, and there are so many other factors that have really made the 2002 code a little obsolete. So if at all we bring about certain changes and bring about a new code with respect to the new environmental situations today, that will be a great service done to the medical fraternity. Now, as far as the working of the medical councils are concerned, I think medical councils basically function, the doctors themselves are the ones who run the council. Doctors are very good when it comes to medical sciences, but when it comes to legalities, they are not very good at it. And it is but natural, because when you are a master in one particular branch, acquiring mastery in another branch might be very difficult. So as far as legalities are concerned, it sometimes becomes a little problematic, because medical councils are basically quasi-judicial bodies, and the only thing that they have got to uphold is uphold the principles of natural justice. That means what? Whenever there is an allegation made against the doctor, the allegation must be made known to the doctor, and whatever his defense with respect to those allegations, they must be properly heard. The doctors must be properly heard, the patients must be properly heard, and then there has got to be a speaking order. This is the only thing that is required to be done, but somehow many a times this is not properly undertaken. I know about cases where, you know, there are expert opinions that come on record even after the hearing is over, and the parties are not given a copy of this expert opinion, and the decision is based on this expert opinion about which the litigants are not even aware. This is not correct. This should not happen. So a lot needs to be done with respect to the medical councils, and what is more important is the medical council, people who man the medical council, they must also have a good legal background. If at all they do not have a legal background, some courses must be conducted so that they know what the functioning of a quasi-judicial body should be like.
Thank you so much for speaking to us today.